Start in 5 seconds. Start. The issue of whether a judicial officer has been actuated by an oblique motive or corrupt practice has to be determined upon a careful appraisal of the material on the record. Direct evidence of corruption may not always be forthcoming in every case involving a misconduct of this nature. A wanton breach of the governing principles of law or procedure may well be indicative in a given case of a motivated, if not reckless, disregard of legal principle. In the absence of a cogent explanation to the contrary, it is for the disciplinary authority to determine whether a pattern has emerged on the basis of which an inference that the judicial officer was actuated by extraneous considerations can be drawn. Cases involving misdemeanor of a judicial officer have to be dealt with sensitivity and care. A robust common sense must guide the disciplinary authority. At one end of the spectrum are those cases where direct evidence of a misdemeanor is available. Evidence in regard to the existence of an incriminating trial must be carefully scrutinized to determine whether an act of misconduct is established on the basis of legally acceptable evidence. Yet, in other cases, direct evidence of a decision being actuated by a corrupt motive may not be available. The issue which arises in such cases is whether there are circumstances from which an inference that extraneous considerations have actuated a judicial officer can legitimately be drawn. Such an inference cannot obviously be drawn merely from a hypothesis that a decision is erroneous. A wrong decision can yet be a bona fide error of judgment. Inadvertence in is consistent with an honest error of judgment. A charge is misconduct against a judicial officer must be distinguished from a purely erroneous decision, whether on law or on fact. The legality of a judicial determination is subject to such remedies as are provided in law for testing the correctness of the determination. It is not the correctness of the verdict but the conduct of the officer which is in question. The disciplinary authority has to determine whether there has emerged from the record on or more circumstances that indicate that the decision which forms the basis of the charge of misconduct was not an honest exercise of judicial power. The circumstances let into evidence to establish misconduct have to be sifted and evaluated with caution. The thread of disciplinary proceedings must not demotivate the honest and independent officer. Yet, on the other hand, there is a vital element of accountability to society involved in dealing with cases of misconduct. There is, on the one hand, a genuine public interest in protesting fearless and honest officers of the district judiciary from motivated criticism and attack. Equally, there is a genuine public interest in holding a person who is guilty of wrongdoing responsible for his or his actions. Neither aspect of public interest can be ignored. Both are vital to preservation of the integrity of the administration of justice. Done.